Hello, and welcome to our special segment on a landmark constitutional court judgment delivered on June 21st, 2024. The case involves AFGRI Animal Feeds and the National Union of Metal Workers South Africa, or NUMSA. Let's dive into the details.
AFGRI Animal Feeds, a division of Africa Foods, dismissed several employees for misconduct following an unprotected strike. NUMSA, stepping in, referred the dispute to the Labour Court, claiming unfair dismissal.
Your Honor, NUMSA has no legal standing to represent these employees. According to their constitution, membership is restricted to workers in the metal and related industries. AFGRI operates in the animal feeds industry, making these employees ineligible for NUMSA membership.
Your Honor, under Section 200 of the Labor Relations Act, NUMSA has the right to represent these employees. The Act allows a trade union to act in its own interest, on behalf of its members, or in their interest, irrespective of the industry.
The Labour Court sided with AFGRI, ruling that NUMSA could not represent the employees due to their industry-specific membership limitations. The application was dismissed with costs.
We appeal this decision on the grounds that it affects the employee's right to representation. Fairness and access to justice must be prioritized. While NUMSA may not engage in collective bargaining for these employees, it can ensure they receive a fair hearing in court.
The Labor Appeal Court overturned the Labor Court's decision, emphasizing fairness, the right to representation, and effective access to justice. They allowed NUMSA to represent the employees in the unfair dismissal dispute.
Your Honor, the issue remains whether NUMSA can legally represent employees who are ineligible for membership under its constitution. The scope of NUMSA's operation does not extend to the animal feeds industry.
Your Honor, Section 200 of the Labor Relations Act provides broad representation rights for trade unions. This case is about ensuring employees have access to justice and representation in legal disputes.
The Court has considered the arguments. According to Section 200 of the Labor Relations Act, a trade union is indeed allowed to represent its members. However, it is also bound by its constitution. NUMSA's constitution restricts membership to the metal and related industries. Therefore, NUMSA cannot legally represent employees from the animal feeds industry.
The Constitutional Court unanimously held that NUMSA lacked legal standing to represent the dismissed employees in this case. As such, the appeal by AFGRI was upheld, and the Labor Appeal Court's order was set aside, with each party bearing its own costs.
This ruling highlights the importance of trade unions adhering to their constitutional boundaries when representing members, ensuring fair and lawful representation. Thank you for joining us, and stay tuned for more updates on significant legal judgments.